Okay. All right. So again, in presenting the record here, we have called Carla Culvert and 23 CR 1647. Is that you?
Yes,
ma'am. And you are here with Ms. Mantellini, your attorney and the state's attorney. You have earlier pleaded guilty to the second-degree felony of aggravated assault causing serious bodily injury with a vehicle. And the pre-sentence report has been prepared and the parties have no objections other than you're going to make comments, I guess.
clarifications and what we disagree with, that we don't want the judge to take as fact.
All right.
Or in other
All right,
people's
then it's
rendition.
made a part of the record subject to any rulings the court may subsequently make based upon differences of opinion.
Yes, sir.
And go ahead, the defendant may proceed.
Okay, I'll start with those three items. There are comments in the section of page 1 that begins on page 1, statements of interested parties. And of course, the interested parties have the right to express their feelings and whatever their opinions are. But there are a few things I just want to clear up. On the bottom of page 2, I think might be the first time somebody mentions that the police didn't search her car, and the parties that there at the time found her purse and it had meth in it. I don't know if they had reported to the police and the police didn't do anything about it. But as far as this report goes, my client says that she didn't have anything, and I don't know if they found anything in that purse or anything, but I would ask the court to disregard those sorts of comments regarding an illegal substance that we don't even know if it was there or not. The second thing was, it is mentioned several times about the car wreck that she was in and her boyfriend was killed. I think the probation officer included that she was also on life support. She was a passenger in that car and not the driver in that car. And I did not want the court to be misled into thinking that she had caused that accident and caused the death of the other person. And the third thing, 1 second, Your Honor, was, and a witness is going to have their perception from their vantage point, and that's why we have trials for different witnesses to take the stand and provide their perceptions of what they saw. But when one of the witnesses, her perception was that it looked like to her that my client just backed up and then just floored it intentionally to smash into the man. What we do say is that we agree that the state had sufficient evidence to find for a jury or the judge to find that that it, regardless of whether it was when she put it in reverse or was putting it back in gear, and what happened, whether the car lunged forward, you know how they sometimes do. I've experienced that myself over my driving experience, but we definitely could acknowledge that it was reckless for her to even have had her hand on a gear shift when there was a person standing in front of the car. But the perception that it looked like to somebody that it was an intentional mow down, I would ask the court to just take that as a witness's perception, but not fact, and not a found fact in this case. And that was all I had to argue about on the report.
Okay, on that last
Yes,
part, the defendant entered a plea of guilty and signed this document under oath.
Yes, sir, intentionally, knowingly, and recklessly. And we do concede that it was reckless for her to do that. And believe that.
Can I finish and then you can respond? I know you're anxious to get the point in. I know what your point is going to be. But really, what this fully states is, I understand what I'm charged with. I am aware of the consequences of my plea. I am mentally competent to enter my guilty plea. I have read the charging instrument. My attorney has explained it to me. I have committed each and every element alleged.
Well, then if it is my fault that we did not put only as to reckless, then that would be on me and not on her, because I've never gone in and torn apart an indictment in the plea papers to single out a single finding. In all my years, I never had it found it necessary, but apparently it was necessary this time. And if it was necessary, I would ask that we be allowed to amend those plea papers to say as to reckless.
Are you asking to withdraw your plea?
No, sir. We still believe in what we're pleading to.
What else did you want to say?
Okay, so after that, moving on from the pre-sentence report, I can tell you, and you'll have an opportunity, and she'll have an opportunity to speak with you. I know that there are lives that have been drastically changed. She's just, when she speaks to me, she's in tears almost all the time. It's not something that she's just like, well, I don't care about that, or I don't care about that. She cares about it all. And in her recollection, she did not push that gas pedal. She did not intend for that car to go forward and hit that man. And the resulting injuries are just devastating, not only
What caused the vehicle to move forward? An act of God?
No, it sounds like to me that, you know how sometimes engines are racy and when you put it in gear, it lunges forward. That's all we can figure is maybe something like that happened, because she says she did not jam on that gas pedal and and hit him intentionally to hurt him, or even intentionally to make the car move. It just jumped when she changed the gear, and she shouldn't have been in any gear. And that's the problem. But she is, she has hopes for being able to take this lesson and do something with her life. She wants to get her GED. She has family support. I think that the truth is, if you read the comments of probation, the evaluation, and the recommendations, I couldn't have put it any better, pointing out the valid reasons why this woman not only could benefit from probation, but maybe is the appropriate thing for her to have an opportunity to do under your supervision. There are definitely cons that he puts in here, and they are true too, but it's almost like he was trying to be painstakingly fair with, in this particular situation and with this particular defendant, that probation is just not an impossibility. It's not really a foregone conclusion that she should not have that. And she is asking for that opportunity to have that. I believe you've got some support letters. I did provide them to the state. And apparently this is, if you wanted to believe that she intentionally and knowingly crashed into that man, and that would show her to be a very violent person. But as you see, she has no violence in her history, and her family does not feel like she's a violent person. It was really bad situation, and I'm sure she could go back and take it back. She'd just take the car and walk away. But there's not going to be anything to take back.
Am I correct the way I'm reading this, that the victim was in the midst of attempting to repossess the vehicle?
That's correct, John.
Okay.
And it'd be easy to think that it's just a retaliation thing. I'm going to get you.
Why would you say that?
Because I know that's how people think, but sometimes it's not that way.
Would they think?
Well, they don't all have to think the same way, regardless of why.
Maybe it's just rational thought.
It could be, but it doesn't always have to be true. And sometimes there's an exception.
It doesn't have to be, but.
And that's what we're asking.
Really,
to recognize.
Man, I've lived a long time myself. I mean, we live on experiences.
And I've had a car that lunged forward when I put it in gear. I know what that feels like.
When someone was trying to repossess your vehicle?
There was nobody.
Well, don't you see really a state of mind?
Yes.
Where there would be a motive here?
And that's what I'm saying.
We can't speak at the same time.
Gear. Well, I'm trying to make sure that you hear
me. I
know,
but let me speak and then you speak, okay? It's a motive. That's obvious, right?
No, Your Honor.
You don't. Are you saying she would not have a motive if someone is trying to repossess her vehicle? She stays in the vehicle, does not cooperate with that, but puts it in a gear.
She might
and
have
moves. Can I just
I thought
finish
I thought
anything?
I heard a period. I thought I heard a period. Go ahead. I'm sorry.
Don't you see that as really common sense that there would be a motive there?
Are you asking me?
Yeah.
I'm saying that, yes, I can see how that would be a first thing. But even in the probable cause affidavit, I think that the officer recognizes that
He says
She
there's no
wasn't sure
motive.
how it accelerated and whether or not intention to harm. She was reckless, and we agree. It was reckless for her to even be in the gear position of any position of the car. And sometimes cars do lunge forward. And it could look like from somebody on the sidelines that they plowed forward. I mean, there's all kinds of variables, but in this particular instance, I believe that she is remorseful about all of the injuries and the whole event. But I believe that she was reckless in the event. But to say that she was intentionally plowing the man down, I believe that's in this particular instance with this particular defendant, in light of a repossession of. I think there's an opportunity for the judge to recognize maybe it wasn't an intentional act like everybody else might think from the sideline.
The victim who was present, not you,
Right.
says otherwise.
Well, and I'm sure everyone would have their opinion. Yes, sir. And their
So what-
position. I can't imagine he would want to give her even an inch of grace terribly and lifelong. But I'm just asking the court to recognize it. And if she had been driving down the road and seen it and like run over him, that's one thing. But there are incidents that occur that are not the based on malice. And she believes that she did not smash on that accelerator. She did not cause that car to run into the man, and she jumped out immediately and started assisting him with his injuries and trying to put a tourniquet on it. She didn't jump out and run away. I mean, this was a very real event and not anything that she had intended. Have I correctly described everything? If I missed anything that you want me to add before we pass the. Well, the only thing is.
You looking for Judge Nyland? Ms. Nyland? Or-
So it did. The commission of this act.
I'm saying that she put her went into gear. I believe that's when he was lifting the hood, and she should have not ever put it in gear, and anything after that should have never happened. But that's what she has done. These injuries to this man and his the trickle down effects to his whole family. But that's what she.
Why would she have done such?
I think he wasn't. My understanding was he under the hood when you put it in gear?
No,
And what was your intent when you put it in gear?
they just have it when you go in reverse, automatically I put it in drive, but before
Why did it in reverse? That's the question.
I was trying to keep him from opening the hood.
Okay.
But he was not.
Judge, this is going against all the evidence, and I'd ask at this time that the state will be allowed to withdraw its plea bargain agreement with the defendant. She's not acting responsible. No, you're not. When I withdraw the state would respectfully withdraw a plea bargain agreement with the defendant.
I would ask that the state reconsider. She is acknowledging that she put that car in gear,
No.
but she should not have had her hand on the gear shift, period. And what the ensuing events that occurred are the elements the state sought just to prove. And why, just because we are trying to make it be evident that her heart, which one was the one that she would, that maybe if the state could prove all three of them, maybe they could. Maybe they only proved one, maybe they only have to prove the other. But she knows that the state could prove because of her behavior. We would have to reconsider, let her take responsibility.
No. The state would respectfully request to withdraw her. She's telling falsehoods that I know that other witnesses all say he was under that hood whenever she started all this. She didn't just put it in one gear, she put it in two gears because she backed up with him under the hood, and then she proceeded to put it in drive and to drive forward, and she's not accepting. I understand she doesn't want to be punished, but I can't in good conscience continue with this if she's not going to accept full responsibility for what she did. And besides, the complainant in this case is already fully adamantly against the plea bargain that the state has made. And I know that since he's present in this courtroom, since he's heard this story, that he's even more so. And so is the state of Texas. So we would respectfully request to be allowed to withdraw our plea bargain agreement at this time and remove that cap of 7.
Well, anything in her attorney's argument on her behalf has caused you to change your mind.
Her testify when she just said what she said, that tells me where she's at, and that's it. I'm done.
Is it? Well,
No.
The thing is, though, that's how she remembers it, and that doesn't responsibility for the entire event. The entire event, regardless of what ensued, she is taking responsibility for it.
All right, anything else?
No, Your Honor.
I'm going to grant the state's request. And in addition to that, the court will note in statements of interested parties that as part of the pre-sentence report, the victim is greatly dissatisfied with this plea agreement and has asked the court to reconsider and impose a lengthier term of incarceration. I cannot do that under the terms of this agreement. I'm capped no more than seven years in prison. So for that reason, well, the court is going to grant this state's motion, and also that wasn't made. The court was going to refuse to accept the plea bargain agreement based upon what the pre-sentence report provides. So that puts us back in square one. And then what we're going to do is set it for trial.
Yes, sir.
Okay.
I haven't had an opportunity to discuss with her how the trial system works in our court. So I guess
Our system works by law.
Well, I'd like to explain to her the law.
Yeah. And it will be set for trial, and y'all can talk and tell me if we need to take up another hearing as to representation.
Okay.
Okay.
And shall we maybe be able to do that today while we're here, or do you want it on a different day?
Whenever
I mean,
I'm here, I'm taking care of business here.
See what she wants to do.
Yeah, so I'm here. The quicker we move forward, I think would be the better for everybody. Yeah, we need Carla Tolfa. I need Miss Culver's file, please. Thank you. There we go. Thank you. Okay, we recalled cause number 23 CR 1647. And Ms. Culver, the court just for the record here, you were before the court for sentencing. The court, well, the state of Texas requested that be withdrawn for this agreement. And the court on its own, also upon review of the file, felt like the offer that was being proposed to dispose of this case was not in the best interest of justice for all concerned. And then we, by that revocation and also that withdrawal of the offer and the revocation by the court of the plea deal, then it will be automatically set for trial unless some other disposition can be reached. Do you understand?
Yes.
And Ms. Mantalini is able to represent you for trial. And nobody should be talking you out of allowing the public defenders to try cases, or else we'd all be in trouble. But you have an option here. Ms. Mantalini is competent to try cases. And it may go to trial quicker if you agree to release her, but that's your decision. The rules of the Indigent Commission, who are strict, and they deal with us in every county every 2 years. And I've been even in front of the Indigent Commission as a whole on matters of review. So I know what they think about that. Their rules are to be followed 100%. No one can pressure you about making a decision.
And if for the record, I have not pressured her to do anything, Your Honor. I just don't want it to look like I have.
Don't let guilty conscience come out.
It's not, there is no guilt in this conscience.
But the Indigent Commission is going to also look at our track record and the odds. They know what is acceptable in odds of people making decisions in this regard. It would probably go to trial quicker if that's what you want. A quick disposition at trial, releasing her is a good idea for you, because we can get somebody off the trial docket wheel, who are ready, willing, and able to try cases and get to it. The public defenders, like she is, have a lot of cases, and most of those, if not literally all of them, are either disposed of by a plea or they go to trial, and generally another attorney is assigned to represent them because the defendants, an accelerated trial, and I can appreciate that. What do you want to do?
I want to release him.
Okay, you want a trial quicker than what probably she would be able to prepare for it. Okay, then I'm going to grant that. The next person on the trial docket will, you don't get to pick them, and I don't. It's the next person, whoever's in line. I don't know who it is.
Yes,
Because we have a large number of people who are competent criminal lawyers, and they're going to, it'll be the next person assigned. I will inform them of that, and then we will place it on the trial docket. And if there's an attempt to dispose of this without a trial, let me know.
yes. Thank you, Your Honor.
Anything else? I think that is it. Is there anything else on our docket this afternoon? Oh, we are in recess. Thank you.
Thank you.